So my name is Beverly Franklin. Thank you so much for joining us today. This is actually the first of our kind of a hybrid event for the NVAR forms changes webinar. So we have people joining us online. There's a camera over there. We have a good group of people joining us in person for some snacks and some refreshments for those of you who are missing out at home. We hope to see you next time. So as you know, MBH education is very important to us and to providing it to our partners. So we want to thank you for being here and also remind you that MBH University provides so much more than just the NVAR forms changes, but we also have a full 12 months of education, and we have an annual event that's in person every year in May. And I know a lot of you in the room, I can see some familiar faces that you joined us this year in May, so thank you for that. There will be a QR code coming from Colleen with the materials for this class for those of you joining us online, so you can follow right along. And I'm thrilled to introduce Colleen Sweeney as our managing attorney and member of the NVAR Standard Forms Committee to present the changes today. So thank you for joining us.
All right, guys, so excited to be here. I always love to teach the form changes because it gives me lots of good questions, the opportunity to interact with people. We do have a pretty full group here, and we have about 300 people signed up online, so I can't take questions. It's just not a format that I can do that. We wanted to do this hybrid event because that's what people had asked for. However, right here is my cell phone and my email. With questions, I do ask that you email me. I have 5 closings today. I might not get back to you right away, but I will get back to you. So go ahead and send me any questions that you have in terms of as I go through this presentation. And we'll also monitor the chat. But if you want a response more quickly, I suggest doing it as an email. So I'll also stay after a little bit if you guys have any questions. So the NVAR form changes are always a lot of fun. People get excited about them. Some hate them, some love them. I'm going to walk you through them. Obviously, in the last couple of years, the NAR settlement really drove the form changes and kind of derailed what we were trying to do as a forms committee, which is always improve the forms because we were really focused on making sure that they were legally compliant. We continue to focus on that, but also we're looking at member feedback to determine the best way to address the form changes. So, whoopsie, Bev, that doesn't want to, I'll do it from here. Can you just get that started? Oh, there we go.
I think it's working.
Okay. So these are the 4 changes as of July 1st, 2025. And what you can do is you can always look on NVAR's website, and it has on there when you go to their website, and here is the QR code. So if you're following along, you can use this link, and what you'll see is like you can always see the educational version, not only from this iteration of changes, but the last one and the last one. Sometimes that's really helpful for people to say, when did this change? You know, kind of why did it change? So know that that resource is available to you. And so also, just so you guys know, if you click on these links, you can see the educational versions because what you're seeing in your forms platform right now are not the July 1st changes yet. So when you click on these, you'll see them, they'll say educational version on them. And that's a good way because you don't want to be looking at them for the first time on your platform on July 1st. My suggestion is that you guys want to be seeing them now. Kudos to you for doing this ahead of time. And so that's an important thing for you to know where they are and to be informed about the form changes ahead of time. So I'm going to walk you through them today, but before we do, I want to just talk to you guys about why do the forms change, because I was the chair of the committee and the vice chair and been on the committee for several years now, and people always say, why do you do this, Colleen? And I don't do this, right? But we have to change the forms, right? And here's really what you guys need to know. July 1st, the law changes in Virginia. We're always updating the forms as it relates to the law. And, you know, Resale Disclosure Act just seems to ever be changing. I know y'all hate it, but it's just, you know, we have to make it as compliant as we can with the statute. And then again, changes are made every 6 months as needed to clarify and improve the forms. And when we talk about clarifying the forms, let's talk about what we do. What really drives the changes is the legal hotline. You all don't like something in the forms, call the legal hotline and let them know why it is. Ariane and Maria answer the hotline. And at the end of every month, they compile all the questions that were come. And you know what happens is we see patterns, right? We see the same thing over and over again. And when we see those patterns, we focus as the Standard Forms Committee on that. Okay, so the Standard Forms Committee gets that report. The chairperson gets to set the agenda of what's particularly important. And then, of course, the law changes. So NVAR members, you all can influence how these forms are used in everyday world and how they get changed. Even if it's a small thing that just gets on your nerves, right? And you just say, that's a little bit ambiguous. We want to hear about it. That's what we think is really important. So if there's any areas of confusion, either Maria and Ariane can tell you, here's why it isn't ambiguous, or here's, thank you so much. We definitely want to make sure we're making changes to the form. So that's a really important part of this because, like I said, so many people say, why does this happen so often? Okay, so I'm going to talk you through the roadmap of the changes. And sometimes I think the best thing to do is just talk about which forms change. So the rental application change. I will tell you this, since I'm presenting this today for MBH, I'm not doing the rental or property management stuff. I am also teaching this class in person at NVAR on July 17th. I will address them at that time. And I would really suggest to you guys, NVAR has a lot of people teaching it. You don't have to take it from me. And if you're going to take it twice, you should probably take it from different people as well, because we all have a dynamic way of addressing the forms. So the rental application changes, the sales contract for unimproved land, the final walkthrough. This is just a new title for the form currently named walkthrough inspection. This is, again, when you go to look for it, and as of July 1st, you guys are going to know. It's going to be called final walkthrough, same form. Buyer's acknowledgement of potential adverse consequences. This is a really good form. Be aware of it and use it. The residential sales contract, of course, it changes every time pretty much. The VA financing contingency, okay, the pet addendum, the lease, the well and septic. There's a lot of changes to well and septic. And I'm going to go over them today, but there's full classes being taught on well and septic. If this is something that you all are using a lot, you should go to one of these classes, okay? Because the law changes pretty substantially. That being said, inside the Beltway, we don't see this as much. The addendum for the lease, the optional listing information sheet, understanding your rights under the Resale Disclosure Act. I'm going to spend some time on this. This one's really important. New home sales addendum, and the optional buyer cover sheet, and the loan assumption addendum, which is really important as well. So I'm also going to tell you about something NVAR really wanted to do, was put language in you all's hands to help you with things that don't come up every day. We don't want to add them to the contract because, as we were talking earlier, you know, we're trying to keep the contract not too long. So this is actually going to be a clause library, okay? And the clause library is just starting. The one thing I can't tell you is exactly what it's going to look like on your platforms. I don't have access to your platforms. So this is something that each of the forms providers are working on. But really the goal is to put like frequently used language in your hands so you don't have to write it. So it's going to be, you can pull it, you can tailor it, and we're going to talk about that. So in terms of the first edition of the clause library, what we have is going to be for the use in the sales transactions. There's going to be an extension of settlement date. Obviously, we need this all the time. Extensions of contingency deadline, the withdrawal of an offer. This is an email. This is something that people stress about, like, how do I withdraw my offer? And so because it's not part of the contract, we'll talk about this, but it needs to be in an email because you don't have a contract yet. It's not an addendum. So a backup contract addendum, the as-is property condition, the exchange, a 1031 exchange for both the buyer and the seller, and the real estate cooperative addendum. Some of you guys are looking at this going, this is the things that were already in the contingency and clauses, partially. So another thing, you're here early. When you're looking for those form changes of July 1st, you're like, where is that? Now you know it's going to be in the clause library. All right, for leasing transactions, early termination of a lease, when the tenant requests, there's an addendum, the early termination of the lease. Again, NVAR's goal is to continue to expand this clause library. Again, call the hotline. If you say, this is something that we could do to standardize this in the industry that would be helpful for everyone, this is exactly where we're looking for feedback. That would be an excellent way for us to make sure that we're doing that for you guys. All right, the big one, the residential sales contract. This is the one that everyone usually asks about and says, Colleen, please go over this carefully. So we're going to spend some time on it. But what I want to say is there's nothing there's nothing earth-shattering on this at all, okay? That's okay. So the sales contract for residential sales contract and the sales contract for unimproved land, I'm referencing the paragraphs in here for the residential sales contract. They're mirrored, but the paragraphs aren't exactly the same. But just so you know, the way that we're doing it. Okay, the forms changed in the following way. So you're going to see this at the top of the contract now. It used to be at the bottom. Residential sales contract. The form is only to be used by realtors and other as authorized by NVAR. All other use is prohibited. Let me tell you why I'm saying this to you. So there's a lot of people that do 1 or 2 deals a year, and they call you and they say, can I just get the form? Listen, you don't want to do that. Number 1, it's a copyright violation. And number 2, NVAR is providing a service, and it's a pay for service, right? You guys have to, I know it's hard. I know this happens all the time. And if you want to know the truth, it happens with attorneys. I signed something saying I'm not going to do that, right? When I have access to the forms. You guys should not be giving the forms to anyone who is not licensed. And this is a really important thing. And it's actually, NVAR kind of didn't put a lot of information out about it, but I want to make sure when I'm teaching the classes that I tell you guys about this, because what happens? Somebody gets made an example of. You guys all know now. Well, well, I can't take questions because it's not fair because people can't say. But the question is, how can they enforce that? It's not me that's going to enforce it. It's NVAR. And they can decide that it's a copyright violation and go after people as a copyright violation. So file a lawsuit. So again, these are only to be used by authorized people. Keep that in mind. I know this is something where people are doing 1 or 2 contracts, don't want to pay NVAR, but that's the way it goes. All right, so the big stuff. Paragraphs 2 and 33 have been updated to include the VA loan assumption option under financing and the added new checkbox under additions. Okay, so what does this look like? So paragraph 2, just the VA assumption. I try to highlight it so it makes it really easy for you guys to see where the changes were. And then on paragraph 33, the VA loan assumption addendum. So you guys are like learning something here. We're definitely going to have a VA loan assumption addendum. And that's a really important aspect of the form changes that we're going to spend some time on. All right. Again, it's a new form. We'll be going through it. So some other changes, delivery. No one likes this. I know this is, but it's updated to reflect the law changes, okay, in the code. So again, the resale certificate can go to the buyer or the buyer's agent, all right? That's the change in the law. It's been that way, but we're trying to make it a little more clear because this has caused a lot of confusion, okay? Pay attention to your inboxes, right? Because if you get the resale certificate, it starts the time, right? And according to the law, the resale certificate comes to the buyer's agent only. It does start the time. The delivery of to the buyer of the resale certificate must be delivered in accordance to the terms of paragraph 6. Let me just tell you something here. I think that's a little bit of a trap for the unwary because looking at the law, there's a little bit of ambiguity in it. So if you get the resale certificate, your client gets the resale certificate in any format. If you said email and somebody runs into you in the grocery store, this is Ryan Stewart always uses this example, and hands it to you, consider the time started. Now, is that what the contract says? No, but there is some ambiguity in the law. And so better safe than sorry, right? Start that time ticking. All right. So this is the delivery from the last iteration of the contract, was January 2025. And here's the new one. Delivery may be to the buyer as set forth below or the buyer's agent. That's the new language, okay? This is what you want to know and pay attention to. So again, your practice point here is monitor your inbox, okay? If it comes to you, it starts the clock running for the rescission period. How can you control the situation, right? Like this is what you guys want to know. How do I cover myself? You just, if it's specified to the buyer, the resale certificate must be delivered in accordance to paragraph 6. That's the NVAR teaching of it. And I'm going to tell you, I would just say if it's delivered in any way, assume that the time is ticking because of the ambiguity in the code. And I know that they obviously, you guys, we're always trying to talk to the legislature and say, hey, listen, you know, we really need to clarify the Resale Act and all of that kind of thing. And again, we have a mistake in it. They've acknowledged there's a mistake, but of course, we're not going to get that fixed right away. So that's why I teach it this way. If you get it in any way, shape, or form, consider the time starting, okay? Start counting those days as soon as it's in your hands in any way. All right, the Virginia Resale Disclosure Act, okay, added the 9 p.m. deadline to the delivery of the resale certificate for consistency with other deadlines. I get a lot of questions about this, like why are we doing this? First of all, so the Standard Forms Committee is made up of attorneys and agents. And we hear from a lot of agents, I don't want to stay up till 11:59, right? I don't want to be responsible for such things. And so to try to normalize it, the discussion was, what is the right time? 7, probably not, right? It's the real estate industry. People are doing this after hours. So the compromise right now is 9 o'clock. And that's why you'll see that 9 o'clock deadline in there, all right? Clarified ambiguities relating to timeframes the best we could. So the problem is it's ambiguous in the statute, but we try to make it as clear as possible. The previous language regarding the buyer's preferred method of delivery has been removed because we're just saying this is how it's going to be delivered. Again, we're going to see these are changes that are reflected in the law. The code is there if anybody really wants to read it. But remember, it has to go to either the purchaser or the purchaser's agent now. That starts the clock running, all right? So here's what the new code section looks like. Usually I compare them side by side. I did it that way and I was like, that really looks confusing. So what I want you to do is just look at it. I've highlighted all of the changes. I will tell you that anybody who before yesterday was on top of this and looked at the contract on NVAR's website, this was changed. This section right here, to buyer or buyer's agent. And again, it was looking at the statute and the way it changed, the way it's written is a little ambiguous. And so that had to be changed. I'm just pointing that out to you because that wasn't in the forms on the website until yesterday. So again, I didn't do the side-by-side comparison. I found it more confusing, but again, you've got to carefully monitor. So one other thing I want to point out here that's in here now is that CK 1390, understanding your rights. I'm going to go over that form. This is your friend. This is the best way to explain something complicated and walk through the process. So know this form. Again, we're going to go over it, but it's also in here, which is helpful for you guys to be able to hand it to your clients as well. All right. Paragraph 9, change walkthrough inspection to final walkthrough to reduce confusion as to the purpose and the scope. This is what, just going to say final walkthroughs here, okay? Again, that's why I try to highlight where the changes are made so it's easy to see. Paragraph 23, we moved the language pertaining to the reimbursement for existing escrows related to VA loans because that all is going to be switched now to the addendum that we're going to go over. We included a new subsection B for rollback taxes, land use assessment program to mirror the sales contract for unapproved land. It's actually not new language. And this is the push and the pull as NVAR's forms are getting used further and further out. This is pretty prevalent in other areas. And so the determination was we should put that in there. I would say if you're inside the Beltway, you're not likely to see this. But again, highlighted for you in the event that you are not used to it. So this is paragraph 23. That's what you see, the rollback taxes. So usually the land use assessment program typically applies to properties being used for agricultural or farming. Not going to see this in Arlington, obviously. So check the tax records if you're not sure, if you're not used to doing a lot of stuff in this, in the outer areas and you happen to do one, you need to be aware of how this works. And we can help you too at MBH. So paragraph 27 definition, we clarified the ambiguities relating to the definition of ratification and when the 9 p.m. deadline applies. That's the new definition and when the 9 p.m. deadline applies. So I've gotten a couple of questions about this proactively, so I'll just go ahead and address them since I can't take questions. So there really needed to be a time. There needed to be a time when a contract was binding. And at some point in the past, the contract was changed without really making it specifically clear as to when that contract is binding. And so the final ratification means the delivery of the final acceptance in writing by buyer and seller to all the terms of the contract, okay? And how this comes up, and we get these questions a lot, okay, my client got another offer. Can I accept another offer? Well, you know, has that final acceptance been delivered is the answer to that. And without the definition of a very specific time, that created a little bit of an ambiguity, probably only going to come up in a courtroom, quite frankly, but it is something that, you know, the Standard Forms Committee, the people who are on the Standard Forms Committee that are attorneys, we also have an attorney roundtable, we call it. And so we hear the things going on in courtrooms. And so that's another thing that we do to try to adjust and make the forms stronger. And without that very specific time period, it hadn't created a problem, but there was lots of speculation that it might create a problem. So to answer the question proactively, why was that done? That's the answer. All right. So still in the sales contract, the entire agreement, the language was updated to indicate when the contract becomes legally binding upon ratification. Now we've more clearly defined what is ratification. All right. So moving on. That's the sales contract changes, the contract for unimproved land. That's the big stuff, right? Wasn't that bad, right? So I don't think any of that is life shattering or too much. But again, this is all important things that make the contract stronger each and every time with each iteration. The final walkthrough inspection, this is just final walkthrough. It's nothing. The only other change to it was remove trash compactor to mirror the residential sales contract, trying to make all of the forms consistent. This is the same other than that. Some people felt that it was a little unclear that this was final, and so that was the reason for that. All right, so the new home sales addendum, these changes addressed ambiguities. Again, when we hear that there's ambiguities, we try to address them. And this one is that the inspector can be present at inspections. Kind of seemed obvious, but just to be clear, we wanted to do that. It also included the new timeframes upon pre-completion date of inspectors. So the buyer or buyer's broker and/or inspectors, okay, can have access. And again, the date is now 7 days. So this is the important stuff for you all that are doing the new home sales, making sure that you're aware of that. All right, understanding your rights under the Resale Disclosure Act. This is, I think, an important one and really is helpful for you guys. So paragraph 1B14 updated to change because of the law, right? Happens over and over again. It significantly updated the section on the buyer's right of cancellation to reflect the requirements under the act. And we try to do it in layman's terms, as they say. Clarified that if the parties agree that the buyer has 0 days to cancel the contract, such agreement does not constitute an automatic waiver of the right to cancel. And again, the 9 p.m. Deadline. Let me just say that this is something that has caused a lot of confusion, right? And it's because you cannot waive by law. It's a requirement of the law. You cannot waive. And the part that can confuse people is if you put 0. Well, the way the statute is written is the day you get it is day 0. And that was something, and you guys are all educated, and I appreciate that you're here. That says so much about you, but a lot of people aren't. And so when somebody was able to cancel and they said, wait a second, I thought you told me there was no contingencies. I thought you told me there was no way out. So the goal is to put all of this information in everyone's hands, especially, you know, for buyers and sellers. So clarified that delivery of an incomplete or outdated resale certificate still constitutes valid delivery. And there is no requirement that the resale certificate be current as of the ratification date. Listen, it's the law, right? I hear a lot of complaints about this, but it's just following the statute. A lot of people are surprised by this and they think, well, I got something that is outdated, that's not complete. Doesn't matter. The time keeps on ticking. So keep that in mind as well. All right, so here's the new form, Understanding Your Rights Under the Resale Disclosure Act. I would highly recommend reading it, reviewing it. It's a great roadmap for you to go with your clients. But I'm going to go through some practice pointers here as well as you're doing that. Paragraph B, all right? Important for agents to understand. Should the parties agree the buyer has 0 days to cancel the contract, such agreement does not constitute an automatic waiver of the rights to cancel, right? One of the things I love about this is you're getting the buyers to sign it, right? So they understand. They can't tell you they didn't understand because you've given it to them, all right? The buyer has till 9 p.m. on the ratification date or date of delivery, whichever applies in the case, to cancel the contract unless paragraph 2A3 applies. And that's at any time prior to settlement if they don't get it. So make sure you're providing this form to your clients to help explain the Resale Disclosure Act. This really is a great resource for you guys. And it's a great outline so that you make sure you've covered that important information. And what's the other thing? You've covered yourself, right? Nobody can come back and say, you didn't tell me. You're throwing a lot of information at people. All of these forms are there to assist you. NVAR works really hard to make sure that they're providing you the best forms to help you do your business and cover yourself as well. All right, 1308, buyer's acknowledgement of adverse consequences. I love this form. I really don't understand why this should be used all the time, all right? Alphabetized the order, updated the disclaimer language, added an option for acknowledging the risk of waiver of in-person tour. Somebody and I were talking about that already. Added section for inclusion of as-is clause and pre-post settlement occupancy terms and other. Add a new section for the inclusion of potentially adverse terms to an offer. So what does this look like? So it looks a little bit different. You'll see buyer is not responsible for any loss or claim that may result from the decisions below, and buyer hereby agrees to hold broker harmless for any liability related to that. We added the in-person tour. Okay, and this new section, it's the same concept. It just had to be written a little bit differently because it's pre-settlement, post-settlement, other, and as is. So be familiar with this, be prepared to use it. We all know post-settlement occupancy, it's so funny because on the committee, we get it that, you know, these are so common, they win contracts, but they're fraught with danger, right? They're absolutely fraught with danger. And so this is a great thing to use in the event that you're going to use a post-settlement occupancy. And I feel like if y'all haven't done a post-settlement occupancy settlement with me, something that I always tell people, and this is really important for everyone to know, you've got to tell your sellers, you need to take your post-settlement occupancy, provide it to your insurance provider, and make sure you have the correct insurance in place. Because more often than not, when I'm sitting at the table and I remind people of this, they say, oh, no, I have homeowner's insurance. Well, you're no longer the homeowner. And I guarantee you the first thing that insurance company is going to do is deny your claim, right? So talk to your clients about this ahead of time. They don't want to hear it from me for the first time at the settlement table, okay? So make sure the correct insurance is in place and use this form so you're covered, all right? So again, it's important for you as an agent. Remember to use this in any situation where there's risk being taken, right? What do I love right here? Other. Feel free to fill it in, right? If it's a unique situation, make sure you're using it there. And it's, again, great for the post-settlement occupancy for you all in terms of protection. All right, private well and or septic inspection contingency addendum. So as of July 1st, huge changes in the law on this that impact private well and septic. These changes are in part in response to the legislative changes, a significant part, okay? Full classes are being taught on this, like I mentioned. Make sure you go to one if you're doing private wells and septics a lot. The changes to the form add an option for laboratory conducting water potability tests to be either certified or accredited pursuant to the regulations. This is real technical, guys. Updated the form to reflect the new VA law on mandatory minimum requirements for septic. Combined alternate and conventional septic system types. Clarify that septic inspections must include an inspection of all readily accessible and openable components of a septic system, the pumping of the septic system, and an excavation as deemed necessary by the septic inspector. Remember, the sole risk of damage and restoration still lies with the purchasing party. This came up, somebody told a story that for whatever reason, the septic system was under a patio, right? So that's a problem if you have to move the patio and you have to put it back. So important to keep in mind. All right, I'm almost afraid to show you guys this, but if you do septic inspections, so this is a link to the red line version of the code. And so if you do them a lot, you want to know how the law changed. This is it, right? This is a very easy way to see exactly what the law changes are. Again, if you don't do them very often, I'm going to get out of the way in case you guys want to see that. This is not something you really want to spend too much time on, but I like a red line version, and the legislature puts them out. It's a good way to see how the law changed. All right. So the private well and or septic exception inspection contingency addendum. So you see the well. The party, again, who's doing the inspection is responsible for the restoration. 10 business days the inspector has, okay? Why is that important? Think about the timing of that, right? As fast as we're doing contracts these days, you want to make sure you're keeping that in mind. Be sure your sellers order their operating permits from the Virginia Department of Health as a requirement if you're the listing agent as soon as possible. Again, these are things that take time. And it always takes longer than we think, right? There's holidays, there's a holiday tomorrow. Some people don't even know tomorrow's a holiday in some places. So keep that in mind. Keep the 10 days in mind. That's really important. All right, this one is the new VA loan assumption addendum. Probably, if you've been doing these, you've seen a similar form floating around. I know that myself and a lot of attorneys kind of had their own, information available to try to help. Thankfully, NVAR is now trying to standardize this. It's a formal mechanism, okay, to transfer those VA loans from a seller to a buyer, and it outlines the terms. Like a lot of people wanted to do an assumption, but there's critical information that wasn't being exchanged. So the goal here was by the committee is to try to put everything in that form to help everyone understand what their obligations are. It's not intended to be used with a VA financing contingency addendum. Practice pointer, loan assumptions can take longer than you expect. Be mindful of the timelines regarding your contingencies. I will tell you one thing is they're getting better. The time that we see for the VA loans, the VA came out and said you got to do it a little more quickly, or we're going to take you off, list and that kind of thing. But it doesn't mean it happens quickly, right? And every provider is a little bit different. So this form does create its own contingency. So, okay, so this is what it looks like. And I'm going to walk you through it because it's a new form and spend a little extra time. The prefatory paragraph, as I call it, it requires the buyer and seller to work diligently and in good faith because they have to. This process only works if the buyer and the seller are together and working together. Okay, paragraph 1, it's going to identify the lender, obviously critical information. And it's paragraph 2 identifies the loan term. What's the balance? What's the interest rate? Original term, important. Like how much time is left on it? Date of the note, current payments, principal, interest, and escrow, important. All of that needs to be filled in. So what does that tell you? If you have a seller who's advertising, hey, I have a VA loan, have all that information available. Paragraph 3, note the review period. This was a lot of debate about what that review period should be. 5 days is what it was determined. Seller acknowledges that the payments are current and they shall continue to make a payment. We don't want it to take 3 months and at the table you find out, well, they haven't been making the payments. So this creates the obligation. The seller has to continue to make the payments. All right. The assumption fee and lender charges are going to be paid by the buyer. Obviously you could adjust that if you wanted to, but the reality is this is the way that it's written. It should stay that way in my opinion. The escrow account will be prorated, funded by the seller if necessary. Everybody hates that time when we get our escrow statement that says, well, you don't have enough money in your escrow account. So we're going to be looking at that, make sure that the escrow balance is correct, it's prorated. If the seller needs to pay more, that's dealt with. So the parties will be required to obtain a release of the seller's liability for repayment. This is important as well. So you're defining all of this in there. Okay, here's another part of it. The substitution for entitlement notes that a substitution is only available if the buyer is a veteran. Hopefully everyone knows that, but the parties are going to state in that paragraph whether that substitution will or not be attained. The seller's required, we're putting all of this on, so it's outlined in the document. The seller's required to contact the lender in a timely fashion. What does that mean? Hopefully as soon as possible. to obtain the loan application forms and provide them to the buyer. The parties are required to provide notice to the other of lender approval or denial of the VA assumption, okay? Again, that ongoing, you got to cooperate in this situation. So the contract is void if the lender provides a denial letter that a VA loan assumption cannot be complete and or the seller's personal liability cannot be released. This was a great discussion with us in the committee because obviously if they say, yeah, you can take the VA loan, but the seller's still going to be on the hook for it, right? Nobody wants that. And so that was one of the reasons that we made sure that was in there as well. Outlines that assumptions can take more than 45 days in paragraph 12. That's important so everyone's on notice. And I say that because more often than not, we hear people like, well, I was supposed to move out of my house or I have a new house, that kind of thing. Hey, listen, we hope it's not going to take 45 days and it is getting better, like I mentioned, but it's important. So if the process is not complete, the parties can agree to an automatic extension. So you all fill that in. You can pick out what that is. Is that 10 days? Is it 15 days? You know, and if after that extension, the VA loan is not approved, then the parties can mutually agree to extend or the contract is void. Okay, so it can't be a never-ending cycle. And that was the best way to kind of talk about that. So the one thing I want to just point out, this extended settlement date only impacts the parties' obligations related to the VA loan, okay? No other timelines or deadlines with this extended settlement date. Important thing to keep in mind, you're not keeping other things open, all right? This is, I think, a really great addition. I think it puts a lot of people in a better place because without knowing all of this information, how can you possibly agree to take on somebody's loan? So this is a great addition, I think, that NVAR has put out. All right, that is all of the changes to the current forms. And now we're going to get to the exciting news, the clause library. And again, the goal here is to put information in your hands so you don't have to write it. I know NVAR had put out some information like, you know, the problem is as a realtor, when you're writing stuff, you're putting yourself at risk. You're definitely close to like legal advice, that kind of thing. And so that helps you. That's one of the real things that we want to help you.
I know you don't want to. Is this allowed for PWAR members as well who have receptivity to use the forms? We can use the library as well?
If you're an NVAR member, you can use it.
No.
No, I don't think that they allow that, but
So
you.
that's-
I'm going to ask, yeah. So that's an interesting question. I think that probably you should call the hotline on that one. I don't want to speak for them. I don't work for NVAR. And so I think that Maria and Ariane would be the best person to write that. The question was, if she was a PWAR member, could she use these if she was also subscribing to the forms, just so everybody online could hear. So what is the clause library? Again, it's to put standard language in your hands as NVAR members. So here's a little, I'm not sure how these are going to appear. I've asked this question. I don't know that we have answers to it yet, but the language is going to be provided to the platforms, and each platform is going to probably have to do it a little differently. So not sure exactly what it's going to look like, but hopefully they understand that. Again, the clause library will have language for both residential and for leasing. And users may copy and paste the subsections that apply into their addendums or emails. I'm going to tell you why this is really important as we get to a form. It's really just commonly used provisions, so y'all don't have to write them yourself, right? All right, the first round, all the provisions from 1344, the contingencies and clauses addendum, is going to go into this library. Okay, so when you're looking for as is, that kind of thing, that's where you're going to find them. So a practice pointer is the italicized language in the clause library is only for guidance. Okay, don't copy that and put it right in there, right? So the things that we're going to see is the backup contracts. This is from the 1344, the backup contract as is, 1031 exchange for the buyer and seller, real estate cooperative. Okay, that's all going to be in the clause library now. And so we also have some new form language in the clause library, which is early termination of lease, tenant request. This is when the tenant requests to vacate early after the start of the lease term. And you can choose which portions you want to use, okay? That's all the language, but let's say you don't want the early termination fee, right? You don't even want somebody to know that there could be an early termination fee. Take it out, right? So this can be obviously tailored to your situation. I like that part of it. So it's the same for the landlord request with the lease addendum when the landlord is asking the tenant to leave early, all right? Extension of settlement date, all right? This one is an important one. Sales addendum, if parties to sales contract wish to extend the settlement date, obviously this happens all the time, having standardized language, the way that you use this. And again, look at this extension fee, right? If I'm the buyer and I need another week, and I'm going to use this language, I am not going to let the seller see this because they're going to be like, of course I want an extension fee, right? So be smart. Don't just copy and paste. Think about it. Also, you don't want to use the italicized language at the top. It's just guidance for you all. But yeah, read it, tailor it, and then you can use it. Agents, of course, can choose which subsections. And again, this is just the practice pointer. Think about it carefully what you want to put in there. Every single time a seller sees that you could get an extension fee, they're going to ask for it. So that's why I just want to point that out. Extension of contingency deadline. This is for use with the sales addendum. If a party to a sales contract wish to change or extend any contingency deadlines, remember that changing certain deadlines, such as the home inspection contingency deadline, impacts when the negotiation period or election period goes into effect. So use these as a holistic approach. Remember, when you put anything in a contract, it might impact another aspect of the contract. I know some brokers have said, oh, I don't like this because I feel like, people don't understand how to use it. I believe in you guys. You're going to understand how to use it. You got to read the whole contract. You have to have an understanding of how that works. So that's the language there. All right, withdrawal of offer. Okay, for use after the submission of an offer, but before ratification if the buyer wishes to rescind their offer. I don't know how many times I get panic calls and somebody says, I made an offer. I haven't heard back. It's been 5 days. I'm so frustrated. My clients have found another house. What should I do? Yeah, this is a great idea. So you can withdraw your offer. It can be edited for use by sellers or for any counter offers. Do not use this in an addendum because it's not a contract yet, right? This is an email. And it says that right there. You don't have to put it in there. Again, I'm going to edit that out. But this is important for you guys to know. I think I like the idea of it being standardized also. I mean, there's always this tension of, is it effective? I get this question so often, is it effective, that kind of thing. It also ties back to date of ratification like we were talking about. So make sure that you're using this as an email, all right? All right, so some administrative changes, the VA financing contingencies, that obviously had to address the change to the VA loan assumption. The lease addendum is just to ratify or dated to mirror the sales contract. Optional listing information, remove trash compactor because it's been out of the sales contract. And the seller buyer information offer cover sheet, added an option for VA assumption and financing information to do the new form and remove the trash compactor. So that's it. That's the changes and the addition of the clause library. One other thing that I just thought would be a good use of time is a little bit of information on the escalation addendum. And the reason is that the escalation addendum, we're still seeing it used and often seeing it used incorrectly, okay? And so this is something that has come up in the last 6 months that I wanted to just talk to you about. Again, the addendum modifies the contract. So if prior to the ratification, the seller receives one or more bona fide offers, and that offer would mean the seller would receive an equal or higher net than reflected in the offer, then the contract sales price is going to be escalated based on a number you all put in there, right? All right, and not to exceed, please put in a not to exceed. If the other offers include escalation terms, the automatic increase will be applied to the maximum escalated net of the highest competing escalation addendum. This increase ladders up, so to speak, until the maximum amount is reached, okay? For the purposes of the addendum, net is defined as the sale price less all seller concessions and or payments towards buyer broker compensation. So there's a reason I'm going over this with you. Number one, we see it done incorrectly all the time. See this escalated sales price? My suggestion is you put it on the front page of the contract. Everybody's on the same page about that. But what I really wanted you guys to know, it's a tool that NVAR has put out, is how do I calculate the net? This is very intimidating by people. And so what we saw kind of going on was a lot of people saying, I'll only take your final and best. But then there becomes a question, are you really, because you don't want to do math, are you really doing what's best for your client, right? So NVAR has created a calculator. And so log into your NVAR account and it's scrolling on the member dashboard, okay? And then you just click on it, you download it, and it actually does the work for you, all right? You do need to make sure, like basic math, that you're checking it. The calculator is not perfect, nothing is. My suggestion is each and every time you use it, you re-download it, because they do tweak it. It has had a little of some bugs in it or whatnot. So this is a tool that NVAR has put out that so many people have said, why didn't I know about it? And it's life-changing. So as part of the forms class, since it came out in the last couple months, I thought I would just let you guys know about it. The information's pretty straightforward. How you do it, you hit the reset button every time, okay? And you just walk through it. And the great thing about it is it will tell you what your highest net is, and it will tell you what the second one is, because obviously this is just a piece of the puzzle. If you have a loan where it's cash and you're worried it may not appraise, you might be willing to take less. There's some fantastic classes that have happened at NVAR about all the different things to think about when they taught this class. And I think they're going to teach it again. I would highly recommend signing up for it if they do. But this is a tool that is available for you guys, and I wanted to make sure that everybody knew it. All right, I talked for so long, I'm sorry, but hopefully you guys all got a lot of good information out of it. And if you have questions, feel free to email me, and that will probably be the best way. But I appreciate you guys coming. MBH loves to do education. I love to do education, so we appreciate you guys being here and online.